Approximately 60% of UK people don't have a will.
It's just so critically important to get a will in place.
Not having it done right is just as damaging as not having one.
If you don't have a will in place with a guardianship provision in it, any minor children can be taken into care. There's a common misconception that the surviving spouse will automatically inherit everything. If there's no one alive in any of those categories, then the Crown will inherit your whole estate.
So today's episode is called Willpower, and it's all about how to get your affairs in order and what actually happens if you don't have a will. So I'm joined today by Abby from Laurus. She's an equity partner, and she's also award-winning in that she got the highest result with STEP when it came to her exam. So we love her. So welcome, Abby.
Thank you.
And
Thank you, Lisa.
thank you for your time. So we know approximately 60% of UK people don't have a will. And I don't know if this is a stat, but I heard 57% of solicitors don't have a will either.
Oh, really?
Yeah.
I'm thankfully not in that category.
So why do you think people don't have a will?
Do you know, I think it's one of those things. It's always on the life admin list, but it struggles to get to the top. I feel like there's other things going on in life that have more of a sense of urgency, but with a will, it's one of those things you can keep kicking, the can down the road. I think until you go through something either personally with a family member and you can see the repercussions of not having a will in place, or you hear about the effect of a guardianship provision for a child, for example. I feel like it's you need a trigger event to really get, the wheels in motion to get a will in place. But
people need to do it.
People do need to do it. It's critically important. We don't have the crystal ball. We've just lived through a pandemic which didn't discriminate against age, and it's just so critically important to get a will in place to protect not just yourself and your assets, but your loved ones, charities.
We've worked on wills, like cases together where they haven't been done right.
Yes,
and
we have.
The outcome of this, I mean, not done right by us. We were picking up the mess afterwards, and not having it done right is just as damaging as not having one, I assume. Is that too much of a sweeping statement?
No, I think, you completely hit the nail on the head. Thankfully, there are some wills that come to light where they're not drafted or there's poor drafting, and we have time because the client has capacity to rewrite them, which is great. But unfortunately, there is also a high number of wills that have errors in them that only come to light when that person's passed away. And the time and cost involved in rectifying a poorly drafted will, it can cost thousands, tens of thousands, all to save a few hundred and getting it properly done in your lifetime. There's a saying that I have: if you're prepared to pay cheap, be prepared to pay twice. And I think that kind of really strikes like how important it is getting your will done properly, because like you said, someone can think they've got it in place and they think that's all sorted, but actually it's not suitable for their circumstances, or it hasn't been reviewed, so it's no longer suitable for their circumstances. And that can cause great difficulties in administering the estate afterwards.
What does actually happen? So let's say I die without a will, I'm married. People would say, doesn't my husband just get everything anyway? So what's the bother?
Yes, that's a very good question. So if you die without a valid will in place, there are government set rules known as the intestacy rules, which will dictate who will receive your assets when you pass away. Those are in place to ensure that your estate can be distributed, but it doesn't take into account a whole host of things such as who would look after minor children, you mentioned children, who would look after pets, your funeral preferences, and so on and so forth. In your circumstance, so you said you're married and you have children, so there's a common misconception that the surviving spouse will automatically inherit everything in that scenario, but actually, under the rules of intestacy, the way that the division works, so the first £322,000 worth of your estate goes to the spouse, plus personal items, and then the balance is actually split 50% to the spouse and 50% to the children, held on their behalf till 18.
The kids could end up being like a major owner of your home.
Absolutely.
And have a say in what happens with it.
Yes, yeah, absolutely. And if they're minors, then you need to have trustees involved, and then so the surviving spouse will be working with trustees,
and that sounds
even
expensive.
To sell that property. It can be expensive as well, and it can also just be really tax inefficient to structure a estate that way. So yeah, that's a perfect example where the intestacy rules don't work for the majority of people, and they're very basic.
Presumably it's even worse if we're not married and have kids, or just not married and don't have kids. But what happens then?
Yeah, so if so the intestacy rules, they don't accommodate for what we call modern families. Like you said, many people are now deciding to live together, not necessarily get married or enter into a civil partnership, and someone's partner has absolutely no entitlement under the rules of intestacy, regardless of the length of the relationship. So if you do want to benefit a partner, you have to get a will in place, nominating them as a beneficiary. And
I see it in the paper often at the weekends. There'll be a couple that have lived together a long time, one working, one stay at home, couple of kids. The stay at home person doesn't get anything if the house isn't in their name and the mortgage isn't in their name. They're not entitled to the house.
Yeah, that
can be a real shock.
That's correct. Yeah, a massive shock at a time that's already going to be hugely stressful for that person as well. So yeah, that further highlights, if you want to make provision for family members or friends or charities, don't rely on the intestacy rules. Because in that scenario as well, a lot of people don't realise that although they have categories of family members, if there's no one alive in any of those categories, then the Crown will inherit your whole estate.
And we do not want that.
And we do not want that, especially if you do have a partner at home, who you've had a longer relationship with.
So there's financial implications, but I assume a huge amount of admin consequences for not having a will.
Yes,
your family are going to be a bit cross with you.
They will be cross. So yes, as well as administrative burdens, there's also cost associated with that, and also risk as well. So the first thing, if someone dies without a will, it's figuring out who's got the responsibility, the authority to deal with the estate administration. And again, you look to the intestacy rules for that. But to give an example of the kind of risk that they could be potentially exposing themselves to, so once you've identified who the administrator is, they have to be satisfied there's no will. Even if they think there's no will, they have to exhaust all the avenues. So that would be going through the documents at the home, reaching out to banks, asking them to check safety deposit boxes, reaching out to local law firms, and then at a cost also doing a will search as well.
Yeah, you had to do that for one of my clients recently, didn't you, as well?
I did, and it's so important because if they administer the estate on the presumption there's no will, and then a will later comes to light, the people that were due to benefit under that will can go against the administrator personally. So they are held personally liable for that. So they have to go through these avenues. It's timely, it's costly, but they have to do it to protect themselves, and that could all be avoided by having a will in place.
And I mean, we're touching on a lot of dark stuff today.
That's my life, Lisa.
But what happens if, so I'm, whether I'm married or not, and I've got kids and I don't have a will.
Yes.
Are these scare stories right, that the kids can become ward of courts and even taken into care?
Yes. Unfortunately, that is true. So if you don't have a will in place, or more specifically a will with a guardianship provision in it, then any minor children will be taken or can be taken into care until social services and the court can determine who's best placed to bring them up.
That's just crazy.
Yeah, it's really frightening.
And so unsettling.
Really yes, and I would actually say the driving force for a lot of parents isn't who's going to inherit their assets, it's who will bring up their children, because the thought of their children being taken away from their support network at an already extremely stressful time is something that really, kicks parents into getting a will in place, because they just hate the thought of that. So yes, you need to appoint a guardian in your will.
And when I wrote my will, I think it sounds like it's a big deal, but I think I literally had a 15-minute conversation. Then the will fairies wrote the will, and then we had a meeting and discussed it. That was sort of the first draft, and then we digitally signed it. It really wasn't a big deal.
It's really straightforward, and I think the thought of doing your will is definitely worse than the reality, and we try and make it as straightforward as possible. So for clients that come with me, I won't make you do a bulky will questionnaire. Just give me an hour of your time in a room. We'll go through all your assets and liabilities to make sure that the will that we're preparing is tailored to accommodate those types of assets and make sure it's tax efficient as well. And then we'll go through the applicable sections of the will that apply to you. 9 out of 10 times we usually have sufficient instruction from that first meeting to prepare a draft, and then, like you said, we'll work through that draft with them, filling any gaps, making sure that they are happy that it accurately reflects their wishes, and then fast forward to getting it signed. We do still need a wet signature though.
Well, that's what I was going to say. I was like, I said digitally signed, and I was thinking, actually, we didn't. We had to go for a second time in.
So for a will to be valid, it has to still, you need the wet signature, and it has to be in front of 2 independent witnesses as well that have to witness you signing. Otherwise, the will could be deemed invalid. What I've seen commonly as well is sometimes a beneficiary witnessing the will. And if that happens, the will itself is still valid, but the beneficiary has disinherited themselves.
Oh my God.
Yes.
Don't sign that if you're a beneficiary.
Yes, so do not sign if you're a beneficiary or if you're married or in a civil partnership to someone benefiting as well.
Okay.
So it's critically important. And with all of our clients, we prefer execution in person so we can see that it's done correctly and we can be the witnesses.
And then so many people say, my will doesn't need to be that complicated. I'll just get one of those packs. I mean, it makes logical sense. They cost £30.
There's a reason that they cost £30.
So what's the counter argument?
Yeah, very good question. So there's a few, I would say, kind of looking at it high level overview. So firstly, having certainty. So as solicitors, we are skilled in drafting. I've been qualified for over 10 years, and because of that, we can make sure that the testator's wishes or intentions are clear. There's no ambiguity. The amount of times I've seen a testator include an asset that you can't actually distribute via a will, such as a joint bank account, or a will that doesn't deal with all the assets that they've got, so then they'll have a partial intestacy. So I'll say that's the first thing. Secondly, reassurance and protection for the beneficiaries. So as we are regulated by the Solicitors Regulation Authority, we have to have professional indemnity insurance in place. And our duty of care extends not just to the client, but it also extends to the beneficiaries as well. So if anything did go wrong, then there's peace of mind that the beneficiaries would have route to financial compensation for any loss that's suffered.
Because will writers aren't regulated, is that right?
No, so it's not a regulated activity. So yes, anyone can claim to be a will writer, but you want to check they're insured, you want to check that they're regulated, and also what solicitors offer in and above that is also checking things like mental capacity. Yeah. So for a will to be valid, you have to have testamentary capacity at the time. The number of claims of people alleging that someone didn't have mental capacity is continuing to rise, especially on the back of the pandemic as well. So as solicitors, we have an attendance note recording intention, recording our findings on their capacity, which we use if a matter did ever proceed to a claim. And if we're under any doubt, we'd get a medical professional involved as well to detail a report and ideally to be one of the witnesses. So that's just another safeguarding to using a solicitor to kind of rebut any allegation of either mental incapacity or undue influence as well, which you wouldn't get from a DIY will.
Let's say I die and my kids are arguing about what percentage who got what, or people missed out on the will that felt they should be in it. A way for them to contest it is to say she wasn't of sound mind.
Exactly that. So even though we live in a country of testamentary freedom, so we're entitled to make a will and leave it to whomever we choose, the caveat to that is certain family members, spouses, children, they can claim against an estate if they feel reasonable financial provision hasn't been made for them. And yes, one of the arguments will be that they weren't of sound mind.
And so you do see it in the papers, don't you? You see it a lot. And reasonably big amounts of money, and then you hear what the fees are going to be.
Yes.
And they've spent a lot of what they would have got on fees.
Absolutely.
To fight it.
Absolutely. I mean, I've got one of the associate partners in my team at the moment, he's quoted on a case, and it's going to be between £50,000 to £100,000 worth of fees for his time. That's not including
the other side.
Yeah, the other side, or the barristers or counsel involved. And the value of the estate isn't even that large, but it will all be, sucked up by legal fees, which is not what that person would have wanted.
No, exactly, not at all. So if in doubt, get your will written properly by someone who's insured.
Yes.
Someone who's done it a lot before, so they know what they're doing.
Absolutely.
And then what are the biggest mistakes you've come across?
I've got 2 real life examples that I can think of. So one of them was where a gentleman, he left a homemade will, and in that will, he left a legacy to his grandchildren. But he failed to include the wording, "to my grandchildren as shall be living at my death." So the omission of those 7 words meant that the number of grandchildren couldn't be quantified because it wasn't limited to those alive when he died. Oh. So in theory, more could have been born in the future, or that's what one side of the family was saying. So before they could distribute his estate, the families agreed to wait till all the children were past childbearing age.
I mean, that could be forever.
Exactly. So that's just an example of how poor drafting can result in families fighting out in the court. There was another one as well where, again, it was a homemade will, and a lady had left the property to one well-known charity and then left the balance to another well-known charity. But she misspelt the charity's name that was inheriting the property. So it raised uncertainty, and a gift can fail for lack of certainty. So although the first charity was saying, well, it's clear, she wanted us to have it, the other charity was saying, no, that gift fell, so we get everything. Oh. So then litigation ensued, and although they settled out of court in the end, it took months and, exhausted a lot of money getting to that settlement.
The charity that were claiming that they were then going to have all of it, is it that they've got a moral obligation to fight it? Or
yes, with charities, it's amazing if you can give to charity, either in lifetime or under your will. But understandably, charities are very, very reliant on these kind donations. So they need to they need to maximise that entitlement so far as possible. So if there is any ambiguity or if there's a question mark, they will enter into litigation to try and get the maximum amount they can, especially if they're quite well-known charities.
And there's a positive, and there's a positive spin to giving money to charity, isn't there, as well?
There is. So any UK registered charities have the charity exemption, which means that any value of money you gift to a charity, regardless of the sum, will pass inheritance tax-free. So that's the first thing. But also, if under your will you gift at least 10% of your estate to charity, then the remaining portion of your estate will benefit from a reduced rate of inheritance tax. So instead of it being 40%, it reduces to 36%, meaning that more of your estate will go to those loved ones and charitable causes that you intended, which is amazing, which is great.
Yeah, it feels like everyone wins a little bit in that way.
Yes, it does.
And then how often should you review a will?
So rule of thumb, we say you should review a will every 3 to 5 years, but beforehand if you have a change of personal or financial circumstance. So to give a few examples, if you have a change of marital status, critically important to review a will. So if you separate, if you're divorced, if you marry, if you cohabit, or if you're widowed. If you have a child, you want to review a will to look at like guardianship, trusteeship. If your financial circumstances change, so a common one is if you receive an inheritance. If you relocate to a different jurisdiction, or even if you just acquire assets in a different jurisdiction, or if anyone named in your will dies as well, you should review it just to make sure that you future-proofed it. Also, which is quite topical at the end of last year, if there's any changes in legislation or estate planning laws, off the back of the budget in October, we've had a lot of change. So a lot of people will be reviewing not just their will, but their estate planning in general, just to make sure it still works.
To make people want to review their will in the budget?
Some of them aren't coming in yet, but there's the limitation now on assets that qualify for business property relief. So a lot of business owners will be reviewing their estate planning. Before, if you had a qualifying business interest, you got the asset was 100% relievable. So we don't say there's no inheritance tax, but they get 100% relief against it. But now they're bringing in a cap of $1 million.
So the farmers need to review their wills.
And also farmers, yes, with agricultural property relief as well. A lot of farmers, understandably, are in uproar about that. So yes, anyone that has assets that qualify for business property relief or agricultural property relief should be reviewing their will.
And another way I think of doing good, I always like to mention this towards the end of the year. I think it's sort of October, November time. There's Will Aid month, isn't there?
There is, yes, in November.
Yeah,
in November, yeah.
And the idea being you sign up and find a solicitor that's taking part, and in exchange for a charitable donation, they'll write you a will.
Yes, exactly. So Will Aid is fantastic. There is also another similar scheme that we participate in that's available all year round as well, called the National Free Wills Network. But very similar premise, that they will cover the cost of a simple will, and it's prepared by a solicitor as well, which is brilliant. And then if your circumstances are slightly more complicated, you can still go through the scheme, but then the solicitor will just let you know if there's a cost that you have a top up exactly to pay. But yeah, it's great because you can get a will properly drafted, but also hopefully you'll consider making a donation to a charity as well.
Well, let's hope that because of today's session, we're going to convince some of those 31 million people that will to write one.
I hope so. Let's keep educating everyone on the importance.
Thank you for coming along.
You're welcome.